What are the defenses to DUI/OVI impaired in Ohio? I'm Shawn Dominy, a DUI lawyer with the Dominy Law Firm in Columbus, Ohio, and this infographic is going to answer that question. DUI, called OVI in Ohio, has two basic types of charges: OVI per se and OVI impaired. The charge of OVI impaired requires the prosecution to prove the driver was under the influence while operating the vehicle. The prosecution's proof comes from the cumulative effect of the individual pieces of evidence, like ingredients in a recipe. For example, unsafe driving, slurred speech, poor performance on field sobriety tests, etc. The defenses are designed to show there were problems with the prosecution's evidence and the result isn't what they claim. The lawyers at the Dominy Law Firm created a summary of the top 100 Ohio DUI/OVI defenses. From those 100 defenses, 50 are related to the charge of DUI or OVI impaired. Those defenses are in this infographic. Also in this infographic is a bonus list of the top 10 defenses to the administrative license suspension. Some of the defenses for OVI impaired are based on the person's driving and the initial detention of the driver by the officer. This is a list of those types of defenses. Other defenses are based on the personal contact between the officer and the driver. As you can see from this list, many of the defenses are based on evidence we would expect to see from a driver who is under the influence and the officer simply didn't observe. After the initial contact between the driver and the officer, there are typically field sobriety tests. The defenses to the field sobriety test attack both the admissibility of the test and the weight that should be given to the test. If there are drugs suspected rather than alcohol, an additional test may be a drug recognition evaluation, and that test also has several defenses. Next, we have defenses based on the driver's conduct. And again, we have evidence you would expect to see from a driver who's under the influence that the officer did not observe. We also have defenses based on the officer's conduct that can affect the conclusion that the officer reached and the weight that should be given to that conclusion. This slide shows defenses based on legal concepts. You've probably heard that an officer has to have probable cause to make an arrest. They also have to make the arrest within their jurisdiction. And you know about Miranda warnings. If statements are made to officers and Miranda warnings aren't given, then the statements may not be admissible. And then we also have this unique defense regarding Ambien. Keep in mind, this list of 50 defenses is not a complete list of all defenses. One important piece of evidence the prosecutors like to use is the driver's refusal of a blood, breath, or urine test. But as you can see from the list in this slide, there are actually several defenses regarding the refusal of a chemical test. Once the case is in court, there may be defenses based on the court process. As you can see in this slide, there are a couple of defenses based on the discovery process, as well as a speedy trial defense. And keep in mind again that there are other defenses based on the court process, but we limited this list to 50, so it doesn't include every possible defense. This is considered a bonus list because the administrative license suspension is actually separate from the OVI charge, although the two are heard together in court. When we represent a client for an OVI case, we also challenge the administrative license suspension for them using defenses, including the top 10 listed here. The Dominy Law Firm represents clients charged with DUI/OVI in Columbus and throughout Central Ohio. If you've been charged with OVI and you intend to contest it, there are a couple of ways you can reach us to schedule a free phone consultation. You can call the number on the next screen, or you can submit a contact form on our website. In any event, we hope you found this infographic helpful.